adjournment. Item number 37, WPC 3854/2022.
Which petition allowed?
Item number 38, WPC 5963/2022.
Petition dismiss.
Item number 39, Criminal Appeal 330/2023.
Appeal dismissed.
Okay, ma'am. Maybe, my lord, in respect of item 41, I have informed the additional PP, my lord. It appears from the office note that the scan copy, my lord, has not come. So since it will be necessary for the bill application, lordship may be pleased, my lord, to fix after vacation. In the meantime, my lord, the scan copy will come, my lord. 41. I have informed the other side.
Mr. Talukdar, so in learned counsel for the accused, press for listing the matter after vacation, immediately after reopening of the vacation. Where is allowed? Raise is also reminder to the learned trial court for transmitting the record for tweet.
My lord, I'm asking for 24th, my lord. Because up to 23, my lord, I may not be available. It may be on 24th.
On 25.
25. Obliged, my lord.
But see, one FAO 16 and W24, we like to withdraw it. Tomorrow it may.
Tomorrow.
I'm taking for listing this CRP, my lord, for motion on 3rd, my lord.
Third.
Third lordship.
What is the motion?
After vacation.
No. Against an, my lord, injunction. My injunction petition has been rejected by the trial court, my lord. Against that, I have come,
Okay.
my lord.
May I beg to mention for listing of a CRP IO for tomorrow, Your Lordship. The urgency is that the learned trial court, assuming itself as an executing court, without there being any execution proceeding, has directed the district collector to make partition. And the district collector, in pursuance to such order, has demolished my boundary one. As such, I have filed a CRP IO. Can be
Okay.
okay.
More possible.
Tomorrow lordship. Tomorrow soon.
So tomorrow as many as 30 cases are listed for hearing. So it is not possible.
Can it be on 3rd?
Third. Okay, we'll try.
May I appeal?
Hmm.
The listing of same case, CRP IO, Your Lordship.
When?
After
On 4th, Your Lordship. On 4th last day.
For
May I appeal, lordship, ma'am, beg to mention listing CRPIO. On
When?
3rd or 4th, lordship, in the lordship.
After vacation.
Some
is there any urgency?
agency is that, lordship, my petition was rejected by Garnet trial court in India. They still fix on 30 October, lordship,
For
for evidence of PW, lordship.
no, immediately after reopening.
Immediately after vacation.
There is no urgency.
On 21st then.
My place, lordship. Lordship, I beg to mention a regular second appeal tomorrow, lordship. What happened, lordship? Last Friday, execution notice is received and date is fixed for execution on 3rd. It's very urgent, lordship. Otherwise, I will evict from the deadline, lordship.
Already a lot of matters fixed tomorrow.
So kindly, it's very urgent. 2nd October.
That's
is
all right, but we have to peruse the record and pass the order. Hmm?
Kindly, lordship.
On 3rd of October, we'll try. Not tomorrow.
May I please, Your Lordship?
Yes.
Okay, for listing of a CRP IO on 4th, Your Lordship.
Okay.
May I please, Your Lordship? Listing a matter for withdrawal, Lordship. Tomorrow,
When?
Lordship.
Tomorrow.
My lord, I am seeking adjournment item 7, my lord.
On the pair being made by Mr. Acer Soduri, learned counsel for the petitioner, SSL is the matter on.
Just adjourn for the day, my.
Okay. On the pair being made by Mr. So-and-so, learned counsel for the petitioner, the case is since adjourned for the day.
Obliged.
Please, your lordship. Please, your lordship. Chief, I beg to mention item number 11. The conducted counsel equality is after station lordship. Item may fix after vacation lordship.
Okay. On the pair being made by Mr.
Arsham,
R. Sharma, learned counsel appearing on behalf of Mr.
equality.
Learned counsel for the petitioner, recessal is the matter immediately after reopening of vacation.
I have one more pair lordship. I beg to mention one IA for listening for orders lordship.
When?
And third lordship. After
Or-
vacation, please.
Is there any urgency?
No lordship.
There are
Already
already so
for
many
withdrawal of amount deposited by the insurance company. That is that.
Okay.
Apply lordship.
I pray for listing of this RFA for admission on 21st, my lord. It has not
October.
been listed,
October.
October.
May I please, your lordship, I beg to mention item number 23, lordship. Finally, matter may be adjourned, lordship. My senior is suffering from fever, lordship.
Who is a senior?
JUNM Loshkar on behalf.
Ms. J. Ghosh, learned counsel for appearing, no, learned counsel for the applicant, price for listing the matter. When?
That lordship.
On 28 October.
As her senior, Mr. R. Mazumdar is suffering from illness. Pair is accordingly allowed.
Obliged.
May it be pleasure, Lordship. Lordship, I beg to mention for listing one MFA in the year of 2015. Lordship, it's a very old pending matter. Lordship, matter may be fixed on 21st of November.
21st
21st
of
November.
October or November?
21st of November.
November.
Obliged. Your Lordship, I beg to mention item number 35 and 36 for adjournment, as the engaging counsel, Mr. Peter Roy Chaudhary, is out of station.
35?
36.
But this matter was listed on being mentioned on the other day.
Yes, your lordship. But due to certain emergency, he has to leave, your lordship.
Okay. Your name?
As they,
Pardon?
as they.
SD.
Miss as the learned counsel for the appellant with consent from the other side, press for listing the matter immediately after reopening of the vacation. Pair allowed.
Okay, may I please?
Yes.
And I am with claimant, my lord. I filed an IA on 29, 2024, my lord. As the insurance company has already deposited 50% of the awarded amount, the time may be allowed.
When? When?
October, my lord.
Okay. Okay. Items from daily list for motion, item number 1.
Please, your lordship. Your lordship, from Silchar to Columbus, lordship. I am the wife.
What is the ground?
I have no source of income. I'm under the roof of my parents. I'm under the roof of my parents. I have no source of income. And it's difficult, so it is difficult to lordship to travel them. And there was 125 petitions pending before the court. His child was in the lordship. He's appeared there. And WS has been filed by the respondent.
Heard, Mr.
Kelly Sharma.
Learned counsel for the petitioner. This petition under section 24 of read with section 151 of the Code of Civil Procedure is referred by the petitioner for transferring of FC within bracket civil case number 475 of 2023. Pending before the Court of Learned Principal Judge Family Court Kasar, Silchar to the Court of Learned District Judge Karimganj, Assam. Mr. Sharma, learned counsel for the petitioner, submits that the petitioner is the wife of the respondent who had instituted one one suit being FC civil number 475 of 2023 before the Court of Learned Principal Judge Family Court, Kasar Silsor. And that the petitioner is residing in her parental abode at Karimganj, and it is difficult on her part to attend the court at Silsor. And besides, she has also instituted one proceeding under section 125 CRPC before the Court of Learned Chief Judicial Magistrate, Karimganj, wherein the respondent has entered appearance and contesting the same. And on such count, it is contended that the FC civil case number 475 of 2023 may be transferred from the Court of Learned Principal Judge Family Court, Kasar Silsor, to the Learned District Judge, Karimganj. The submission of Mr. Sharma needs further consideration. At this stage, notice be issued to the respondent, returnable in 4 weeks, that be taken by registered post with AD and also by result process with till returnable date. Further proceeding of FC civil number 475 of 2023 stands state.
At number 2,
May please allows. Section 24 CPC application also for transfer of a title to matrimonial case from additional district of Sibsagar also to the family court, Kamrup Lecture also. And
Why?
so the ground is that also the financial hardship for the petitioner also, and she is presently residing in Guwahati lordship for earning her livelihood lordship. And she has also already instituted a case under section 125 CRPC lordship, which is already pending before the family court, Kamrup lordship.
Where?
Family court lordship, Kamrup Metro.
Heard, Mr.
Outcome.
Learned Counsel for the petitioner. This application under section 24 of the Code of Civil Procedure is prepared by the petitioner. For transferring of title suit, certificate M, case number 62 of 2023, pending before the Court of Learned Additional District Judge Sibsagar to the Court of Learned Principal Judge Family Court, Kamrup M at Guwahati. Mr. Fukan, Learned Counsel for the petitioner, submits that the petitioner resides at, the petitioner is the wife of respondent number 1, wife of the solo respondent, and she resides at Guwahati, and the title suit number 62 of 2023 is instituted before the Court of Learned Additional District Judge Sibsagar, and it is difficult on her part to attend the court at Sibsagar, and besides, she has also instituted a proceeding under 125 CRPC before the Court of Learned Principal Judge Family Court at Guwahati, and as such, it is contended that the title suit certificate M number 62 of 2023 may be transferred to the Court of Learned Principal Judge Family Court at Guwahati from the Court of Learned Additional District Judge Sibsagar. The submission of Mr. Fokon needs further consideration, and at this stage, notice be issued to the respondent, returnable in 4 weeks, to be taken by the third page with AD and also by usual process until returnable date. Further proceeding of 62 of 2023 stands state list after 4 weeks.
item 3,
Maybe. In this case, my lord, a respondent filed one BB case in the Kamrup, my lord. The petitioner has from Kokrajhar, my lord, and a respondent, my lord, a permanent resident at Gwalpara, my lord, and earlier, my lord, one title suit, my lord, regarding to dissolution of marriage has been transferred to Gwalpara, my lord, by this honorable court, my lord.
Okay, let notice go at this instance.
Miller.
Let notice go at this instance.
Yes.
Heard Mr. A.M. Ahmed, learned counsel for the petitioner. This petition under section 24 of the Code of Civil Procedure is prepared by the petitioner Mohammad Rafiqul Islam for transferring of DB case number 122 of 2024 pending before the Court of Learned Judicial Magistrate Kamrup M at Guwahati. Where it is to be transferred?
Maybe go Gwalpara Miller. I have respondent live in Gwalpara Miller.
No, now it is pending at Guwahati.
Guwahati.
To the Court of Learned Chief Judicial Magistrate, Kukrazar BTC, Assam. Mr. Ahmed, learned counsel for the petitioner, submits that what is the other proceeding?
Miller.
What is the other proceeding?
Miller, one title suit Miller regarding the regulation of marriage Miller has been transferred to Gwalpara Miller from Kukrazan. And because of Miller, respondent lives at Gwalpara.
Mr. Ahmed further submits that one title suit number.
And there is a respondent. And it Lordship order.
Title suit within bracket D number 5 of 2023 is also pending between the parties, same parties, and this court by order dated 16/8/2024 was pleased to transfer the same from the Court of Learned District Judge, from the Court of Learned Civil Judge Junior Division, Kukrazar, to the Court of Learned District Judge, Gwalpara. And as such, the present proceeding may also be transferred from the Court of Learned Chief Judicial Magistrate Kamrup M at Guwahati to the Court of to any court situated in the district of Gwalpara. Peruse the petition and the documents placed on record. Let notice be issued to the respondents. Returnable in forwards that be taken by registered post with AD and also by usual process within a week from today. Till returnable dates, further proceeding pending before the Court of Learned Zen First Class Guwahati, stands state.
Complaints. Item number 4.
Yeah, please, Your Lordship. Right. It is not filed by affidavit on 25/9/2024 also.
25,
Yes, Lord.
but it is not available on the record.
Read file, Lordship.
Oh, yes, it is available. Yes. So what is your pair in this petition?
See the proceeding, Lordship, first. Proceeding, Lordship. Setting aside and passing the order dated 15/7/2024, Lordship. Passed in petition number 276/2024. That was 2024. And as well as Kolkata also record.
document from the circle officer. So the deputy commissioner is and it is the official literature.
How the impugn order passed by the learned trial court suffers from any infirmity or illegality?
What's it, the document which
Hmm?
is very essential of it. The use of the deputy commissioner, circle officer, and as well as the sub providers from the certificate.
So certified copies were not furnished to you.
Yes, sir.
Therefore, you have filed an application for calling the records
Yes, sir.
and also
Use the
to call the authorities to examine as a witness. Okay, we'll pass the order. We'll dispose of the petition.
May I please have it?
Hmm.
Lordship, the impugn order is at page 82, my lord.
By virtue of this order, my lord, the plaintiff, that is the respondents, my lord,
Mm,
they were allowed to file their written statement against my counterclaim, my lord,
mm,
after 90 days, my lord. Kindly see, my lord, the
mm.
application to allow them to file the written statement was filed after 109 days, my lord, from filing of my written counterclaim, my lord. My lord, may kindly come to page 69, my lord. Order dated 15/12/2022, my lord.
Counterclaim was filed on,
Counterclaim was filed on 30/10/2023, my lord. But it was put on record on 15/12/2023. So the limitation period will run from 15/12/2023, my lord.
mm,
My lord, on 15/12/2023, the counterclaim was filed, my lord. Next day was fixed for filing of written statement against my counterclaim, my lord.
mm,
No application was filed, seeking further time to allow them to file written statement, my lord.
mm.
On 17/1/2024 is the next date fixed, my lord. No petition was filed, my lord. Again, next date was filed on 4/3/2024, my lord. On 4/3/2024, also there was no application filed, my lord. After 109 days, my lord, on 2/4/2024, my lord, the plaintiff side has filed an application to allow them to file written statement, and that is still the next date, my lord.
Where is the
The
petition?
additional 5, my lord, page 73, my lord.
What is the ground assigned for the same?
According to them, my lord, the learned counsel engaged by them did not receive the counterclaim, my lord.
From whom he had not received?
From the court record, my lord. Kindly see the order dated 15/12/2023. I have supplied the copy to the plaintiff, my lord. Page 69, my lord. May I read it, my lord?
Not necessary.
It was available on the record, my lord. It was
15/12/2023.
yes, my lord.
No, if the counterclaim was filed along with a copy to the plaintiff,
Hello.
where is the question of not receiving the same by the plaintiff?
Yes, madam. Yes.
Now, what is your prayer?
My lord, I humbly pray before this honorable court, to set aside the order dated 8/7/2024, my lord, by virtue of which the plaintiff were allowed to file their written statement against my counterclaim. Impugn order is at page 82, my lord.
What is your name?
MK Soma, my signature is on the Wakalatnama, my lord.
Okay. Oh, the plaintiff has received a copy only on 2/4/2024.
2/4/2024, my lord.
Hmm.
Even if we calculate from 2/4/2024, my lord,
Hmm.
let us assume that the limitation period starts from 2/4/2024, my lord,
Hmm.
from the receipt of the copy, from the court record, my lord,
Hmm.
despite all other question of law, my lord.
Hmm.
Then also, my lord,
Hmm.
on 8/7/2024, when the order was passed, my lord,
Hmm.
90 days was already passed, my lord, from 2/4/2024, my lord.
Hmm.
Total day from filing, receipt of the counterclaim, my lord,
Hmm.
till filing of the written statement, my lord, 206 days passed, my lord.
Hmm.
And kindly see, my lord, as per order 8, rule 1, my lord,
Hmm.
first application has to be filed within 30 days, my lord,
Hmm.
from the date of receipt of notice, my lord.
Hmm.
So let us presume that he have received the notice on 2/4/2024, my lord.
Hmm.
Then the first application has to be filed on the next date, my lord.
Hmm.
Then, my lord, the honorable court, the trial court can extend time up to 90 days, my lord,
Hmm.
on application, my lord,
Hmm.
as per orders 8, rule 1, my lord.
Hmm.
Kindly see, on 22/4/2024, another application was filed, praying for another date, my lord.
Hmm.
That is Annexure 8, my lord, page 78, my lord.
Hmm.
Thereafter, my lord, the next date was fixed on 29/5/2024, my lord. On 29/5/2024, no application for seeking further time to file WS was filed by the plaintiff, my lord.
Hmm.
The case was again fixed on 26/4/2024, my lord.
Hmm.
Same thing, my lord. No application was filed seeking further time, my lord. And latest judgment by the Honorable Madras High Court, my lord,
Hmm.
passed a few days back, my lord.
Hmm.
So moto extension of time
Hmm.
without any written application is not allowed, my lord. It's not permissible, my lord.
Hmm.
May I submit that copy of the judgment passed by the Honorable Madras High Court, my lord?
Hmm.
Relevant paragraph is paragraph 12, my lord, page 12, my lord. May I read it, my lord?
No, 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 not us.
Here, my lord, the trial court has overlooked the provision of order 8 rule 1, my lord, without any application for further time, granting further time, my lord. So moto has exercised its power under order 8 rule 1 and
Heard Mr. M.K. Sharma. M.K. Sharma or M. Sharma?
M.K. Sharma, my lord.
Learned counsel for the petitioner. This petition under Article 227 of the Constitution of India, read with Section 115 of the Code of Civil Procedure, read with Section 151 of the Code of Civil Procedure, the petitioner has put petitioners, namely Raja Thapa and Srimati Kaura Thapa, have put to challenge the correctness or otherwise of the order dated 8/7/2024, passed by the Learned Civil Judge Senior Division, Tinsukia, in title sub number 58 of 2023. It is to be noted here that by impugn order dated so. The Learned Trial Court has allowed the plaintiff, the respondents herein, to file the written statement to the counterclaim jointly filed by the
Petitioners.
present petitioners, as defendant number 3 and 10, 3 and 10, after a lapse of 90 days. Mr. Sharma, Learned Counsel for the petitioner, referring to the order dated 8/7/2024, submits that the Learned Trial Court, by impugned order, has allowed the respondents to file counterclaim.
WS on counterclaim, my lord.
Pardon?
My lord, WS on my counterclaim, my lord.
WS to the counterclaim filed by the respondents, no, filed by the petitioners herein, beyond 90 days. Beyond 90 days. And beyond 90 days by holding that the respondents have received a copy of counterclaim filed by the defendants on 2/4/2024. But referring to the order dated
12/12/2024.
order dated, which one you have shown me?
My lord, 15/12/2023.
Order dated 15/12/2023, Mr. Sharma submits that while filing the written statement along with counterclaim, the present petitioners follow line two. Submits that by order dated 15/12/2023, the Learned Trial Court has received a written statement along with copy to the plaintiff. Copy to the plaintiff. And as such, there is no question of receiving the same on 2/4/2024 by the respondents herein. Further, Mr. Sharma submits that even after 2/4/2024 also, the learned trial court has extended the time to uh, file the written statement against the counterclaim to the respondents herein without there being an application filed for extension of time. And extension of time so moto without there being an application is contrary to the provision of Order 8, Rule 1, CPC, referring to a decision of High Court of Madras in Ramesh Flower Private Limited versus Mr. Sumit Srimal, CRP within bracket MD numbers 1853 and 1854 of 2024 and CMP within bracket MD number 10508 and 10518 12 of 2024 submits that request for extension of time for filing written statement after expiry of 30 days has to be in writing with good reasons. And after expiry of 30 days, written statement can be accepted only upon condonation of delay in filing the same. And since in the case in hand, the learned trial court has so moto extended the time, and since no application was filed by the respondents herein for extension of time, showing the cause of delay in filing the written statement, the impugned order dated so and so fails to withstand the legal scrutiny and therefore it is contended to set it aside. Para, having heard the submission of learned counsel for the petitioner, I have carefully gone to the petition and the documents flashing record, and also peruse the impugned order dated 8/7/2024. It appears that the learned trial court has observed that the counterclaim filed by the present petitioners was received by the respondents on 2/4/2024. And thereafter also, more than 100 and
My lord, on this date, my lord, 97 days, my lord, past, my lord.
no, you have referred earlier 109 days.
109 days, my lord, from 15/12/2024 to 2/4/2024, my lord.
No, from 2/4/2024
Till, my lord, 8/7 to 90, 5 days, 95 days, my lord.
95 days.
Yeah.
And thereafter also till 8/7/2024, more than 95 days elapsed. Since the aforesaid extension of time was not granted on the basis of a written request made by the respondents. In view of the Order 8, Rule 1 of the CPC, the impugned order appears to be illegal and arbitrary, and as such, the same failed to withstand the legal scrutiny. And accordingly, the impugned order dated 8/7/2024 stands set aside. In terms of above, this CRP IO stands a disposal of this.
Number 6.
Right, please, your lordship. Lordship, in a similar case, my lord has already stated the order in the judgment. My lord, just same case where my lord, I was, despite of giving my representation and my petition, they have, the learned trial court below have rejected my petition for WS. My lord, the parties are, the petition is the same, but the respondents are different. My lord, page 31, my lord.
So why the written statement could not be filed in time?
My lord, what had happened, I had given my lord, the husband of the petitioner, my lord. She had passed away, my lord. And as because she was, the husband of the petitioner was in the business and she was just a housewife. My lord, my petition is at annexure 3, page, para 5, page 28. My lord, in a similar order, my lord's order. Same case, my lord. But the respondents are different. May I read them?
Not necessary.
This is a suit for specific relief, my lord. And I was asked to give my written statement. I was unable to. I paid for 2 weeks' time. But the honorable court rejected your petition.
Okay. Hard Minister,
SP Sharma.
learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner Srimati Mampi Gogol has put to challenge the correctness or otherwise of the impugned order dated 3/5/2024 passed by the learned civil judge Surat entitled suit number 4 of 2024. It is said here that by the impugned order dated so and so, the learned civil judge Senior Division Surat refused to extend time for filing written statement by the impugned order dated 3/5/2024. while the petitioner has filed on petition number 1018 of 2024. On account of sudden demise of her husband, and also on account of her ill health. And also on account of her failing to obtain certain documents. With regard to the business of her deceased husband. Mr. Sharma, learned counsel for the petitioner, submits that the husband of the petitioner died on 18/1/2021, leaving behind the petitioner and her minor daughter. And she could not file a written statement on the 89th day of receipt of notice by her, and therefore she filed an application for extension of 2 weeks' time to file a written statement. But the learned trial court has dismissed the same. Mr. Sharma further submits that the provision of Rule 8, now Order 8 Rule 1 is directory in nature, and the period of 90 days is can be extended if sufficient cause is shown. And in the case in hand, also the petitioner has shown sufficient cause, and therefore Mr. Sharma submits that the impugned order refusing to grant time to file a written statement to the petitioner is illegal. Therefore, it is contended to set it aside. Having heard the submission of learned counsel for the petitioner, I have carefully gone through the petition and the documents placed on record, and also perused the impugned order dated 3/5/2024. It appears that the petitioner has filed the petition. It appears that the petitioner has received the notice, received the summon on 5/2/24. And on the 89 days, he had filed a petition before the learned trial court for extension of 2 weeks' time to file a written statement. But the learned trial court has dismissed the same, that no exceptional circumstance or reason is shown by the defendant. But having gone through the petition dated 3/5/2024. When the petition was filed,
3/5/2024, madam. It's a annexure 3
petition number, what is the number?
1018 2000 1018, madam, 2024.
But having gone through the petition number 1018 of 2024, filed on 3/5/2024, it appears that she has assigned good reason for failing to file a written statement within the stipulated period. That being so, the impugned order dated 3/5/2024 is illegal and arbitrary, and fails to withstand legal scrutiny, and therefore the same stands set aside and questioned. It is provided that the learned trial court shall accept the written statement filed by the petitioner along with the petition number 1018 of 2024, and thereafter proceed to hear the matter in accordance with law. In terms of this CRP, I will dispose of this motion.
Item number. Please, Your Lordship. Item number 9 and 10, it's a similar matter, my lord. The parties are different, the petitioner is the same, the respondents are different, and the petition number is different. 9 and 10. Order dated is same, only the petition number is different, my lord.
Okay,
Item 8.
The improved order at page 80, we came before the trial court, simple prayer of appointing a survey commissioner. Because I am the plaintiff in the suit was filed in the court below. And the simple case is that there was a Kacha road was passing over the land of the plaintiff and also over the land of the defendants. And that road was being used by both the sides for ingress and egress. And as far as the defendants are concerned, in the year 2020, they suddenly built an iron gate with an RCC structure, taking advantage of the COVID period when the courts were not functioning. And thereafter, the plaintiff is put to great difficulty. He is a handicapped person otherwise. And the case of both the sides is contested in the way that the plaintiff is relying upon the fact that the road passes through over his patta lands, periodic patta lands. Whereas the stand of the defendants in the WS is throughout been that the gate as such has been built on his land, which is a Toji land. Therein lies the crux of the issue, whereas whether the road passes through only the patta land of the plaintiff or both parties, or it is only over the land of the defendants. The application was filed on 19/8/2024. The learned trial court, by the impugned order dated 19/8/2024, on the very same day, has rejected the petition as being filed at a belated stage. That is the only ground as such. Lordship has the order dated 19/8 at page 18.
why the petition could not be filed in time?
So what had happened earlier is that the evidence of both the parties was recorded, and thereafter during the cross-examination also of DW1, I have appended the copy of the cross-examination. He has said that I do not have any objection if the survey commissioner is appointed. Well, it could have been definitely.
No, merely because he has no objection, it cannot be allowed. It is the
That is
discretionary
there.
power of the court.
That is there. That is there. But the
Yeah.
satisfaction also of the court has to be recorded simply on the ground of delay, because the law is settled that simply on the ground of delay,
Hmm.
the petition cannot be rejected. There has to be some satisfaction.
So the law,
Yes. But I rely upon judgments of this court and also of the Madras and Orissa High Court. Lordship may kindly take up the judgment of the Madras High Court first.
paragraph number,
Notes paragraph number 7 onwards, perhaps. 7, which is at the second page. Last paragraph. May I read?
yes.
I have carefully considered the case of the parties, arguments of both counsels.
No, which case you were reading?
I am reading the Madras High Court case. Chanmugar High. Well, Lordship has taken the Orissa also. I can read Orissa also. No difference. Lordship may, if Lordship is taking up the Orissa case, para 4 onwards. 5.
No, you first come to the Madras judgment.
Madras para 7 onwards. I have carefully considered the case of the parties, argument of both counsels, perused the records. Regarding the locus standi of the husband of the petitioner to file the application is concerned, court below has erroneously held that the husband of the petitioner, who is not a
suit has no locus standi to file the application. The courts below has failed to see that under section 120 of the Indian Evidence Act, parties to the civil suit, this part lordship may omit. If I may take your lordship to para 10, next page. Thus, when the evidence of one party is completed and other is started, or when the evidence of both parties is completed and the suit went to the next stage, the formal application to reopen the stage of suit is necessary. As mentioned, supra since the Civil Procedure Code. I'm sorry, para 9. Very sorry. Insofar as ground raised opposing the petition that without filing a petition to reopen the proceedings, the petition for appointment of commissioner is not maintainable, is not valid one. It is settled law that if the court deems a local investigation is necessary for the purpose of elucidating any matter in dispute, the court may issue commission at any stage of the suit. There is no prescription of stage to file a petition for appointment of advocate commissioner provided under the Civil Procedure Code. It is worth to see that for examination of witness of parties to the suit, Order 18 of CPC contemplates the step-by-step procedure. If I may take a lordship to the para 11. Next page.
No, here it is stated that it is settled law that if the court deems a local investigation is necessary.
Yes. So the
Here the
has
court,
no, there has to be some satisfaction because by writing one line, I do not find it that cannot be the reason, because here is a case where the claim of the plaintiff is that the blockage or the suit is the land is over a particular dag and patta. The defendant's time is totally different. Only on the oral evidence can the exact point of dispute be located. My limited prayer in the application was that please appoint the circle officer or any revenue official so that the exact locus of the dispute can be, situs of the dispute can be pointed out. That's the limited prayer, because that will help the court ultimately to pass a proper decree in terms of Order 20, Rule 12 also. So these aspects of the matter were not even considered. In fact, our Honorable High Court, I should place the other judgment also, that all these, now in view of the recent judgments of the Supreme Court, all these aspects have to be considered. I would have been satisfied, there would have been a speaking order having considered these points rejected on the merit. Here, the trial court appears to have been influenced by the fact that since the application was belated, so it is not maintainable. That is not the law. So only on that ground, that cannot be, because just writing one line that it does not deem it necessary. There has to be something more than that, a proper adjudication. Now, if I may read the para 11 of this judgment. Admittedly, the present petition for appointment of an advocate commissioner was filed only at the stage of arguments. However, the relief sought for in the suit is one for mandatory injunction and recovery of possession after declaration of the title. When the respective defendant deny the lie and location of disputed construction and specifically assert that the construction is within their property and there is no encroachment, the nature of dispute could be resolved only if the exact location of construction is brought to the knowledge of the court, which cannot be done except by appointment of advocate commissioner. Thus, mere delay in filing the application after the case was posted for arguments is not a ground for dismissal of application, and substantial justice requires the appointment of commissioner is very much necessary to decide the list. Thereafter in paras 12, 13, other judgments of the High Court are the same High Court. So I will just for a minute cite the para 13. In yet another decision of this court, in the case of so-and-so versus so-and-so, AIR 2004 Madras 419, it is held that in a suit for declaration and permanent injunction, the dispute pertaining to portion of adjoining lands allegedly encroached by the defendants and the defendants denying that there was no such encroachment. This honorable court held that the best evidence in such case could be obtained only by the appointment of advocate commissioner. Therefore, in my considered view, no prejudice will be caused to the respondent herein by appointing the advocate commissioner to visit the suit property along with the surveyor and note down the physical features. In fact, the advocate commissioner's report and plan would enable the court for the purpose of throwing more light or enlightening to arrive at a fair decision. Thus, the appointment of commissioner is necessary, and therefore the order of court below is liable to be satisfied. In the result, CRP 7. This is as far as the Maloj. Because the Madras case was very similar to our case. There was a denial by the defendant in that case. Defendant said that construction is on my property. It has nothing to do with plaintiff's property. And Lordship would appreciate that an iron gate and the structure and the blockage, it does not specifically bear any number, etc., which can be identified. Now, if Lordship may kindly have the Odisha judgment. So it's para 8 onwards. Lordship have it.
This is AIR 2017, Orissa 52. May I read para 8?
Yes.
On an interpretation of the said rule in Bhavesh Kumar Das versus so-and-so, this court held as under. In the case of Prasanta Kumar Jena versus so-and-so, the learned single judge of this court held that an application under Order 26 Rule 9 CPC can be considered only after closure of the evidence, when the court finds difficult to pass an effective decree on the existing evidence. Relying on the said decision, learned single judge of this court set aside the order of appointment of survey knowing commissioner for measurement and demarcation of the land passed by the learned trial court. The same was challenged before this court in the case of Ram Prasad Mishra versus so-and-so. The bench, speaking through Mr. So-and-so, CJ as he then was, held that the learned single judge has interfered with the order passed by the learned trial court in appointing the survey knowing commissioner, ignoring the decision of this court in the case of Mahendranath Parida versus Purnananda Parida, yeah, so-and-so. Thus, the decision in the case of Prasanta Kumar Jena has been impliedly overruled by the division bench of this court. In Mahendranath Parida, this court held that when the controversy is as to identification, location, or measurement of the land, or premise or object, local investigation should be done at an early stage so that the parties can be aware of the report of the commissioner and go to trial prepared. In Ramakant Naik so-and-so, this court held that issuance of a commission for local investigation is the discretion of the court. While considering the prayer for appointment of a commission, the court must apply its mind to the facts and circumstances of the case and pass order. No straitjacket formula can be laid down before issuance of commission. The court must be satisfied that there is a prima facie case in favor of the applicant. On a reading of Order 26 Rule 9 CPC, it is manifest that the stage of appointment of survey knowing commissioner has not been prescribed. When the legislature in its wisdom has not prescribed the stage of appointment of survey knowing commissioner, the power of the court to appoint the survey knowing commissioner cannot be cabined, cribbed, or confined. In view of the authoritative pronouncement of this court in the case of Bhavesh Kumar Das, order dated so-and-so, passed by learned additional civil judge, arising out of so-and-so's quest, the learned trial court shall decide the application for appointment of commission on its merits. When this judgment of the Orissa High Court lays down that the legislature in its wisdom has not prescribed any particular stage, so it is for the court to apply its mind in a proper manner, examine all the aspects, and then pass an order in accordance with law. Because it could be otherwise very difficult for the court to pass any decree, any correct decree.
The impugn order is at page number.
It was page number 18. And 6.
Page number
80. Annexure 6.
and where is your petition?
The petition is at page 75.
Third, Mr.
A Ganguly.
Learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has put to challenge the correctness or otherwise of the order dated 19/8/2024 passed by the petitioner in petition number 517. No, passed in the petition number 517 of 2024 under Order 26 Rule 9 CPC filed by the petitioner in title suit number 2022/2022 passed by the learned civil judge junior division number 2 Lakhimpur at North Lakhimpur, whereby the learned trial court has dismissed the petition filed by the petitioner to appoint a survey commissioner only on the ground that the petition was filed at a belated stage of the proceeding. The learned counsel for the petitioner submits that the petitioner as plaintiff has instituted a title suit, being title suit number 22 of 2022 for recovery of cash possession and permanent injunction against the respondent opposite parties over the scheduled land of the plaintiff. In the said title suit, evidence of both the parties were closed, and thereafter the petitioner has filed a petition being petition number 517 of 2024 for appointing a commissioner to survey and demarcate the scheduled land covered by DUG number 764, 768, 769, covered by periodic patta number 46, 190, 234 of Dholpur Avenue Circle. And demarcation of the said land is very much necessary, as the pleadings of both the side land covered by TOSI DUG number 30 is under the possession of the defendant, which is Govt Khas land, and patta number 78 DUG number 762, and the land claimed by the plaintiff is under DUG number 764, 768, 769 are periodic patta land covered by periodic patta number 46, 190, 234 under the Dholpur Avenue Circle. And to arrive at a suitable finding, appointment of the commissioner to demarcate the said land is very much necessary, and therefore it is contended to allow the petition. It is also submitted by the learned counsel for the petitioner that the impugned order now in the impugned order, the learned trial court has only rejected the petition only on the ground that the same was filed at a belated stage. Referring to Order 26, Rule 9 of the CPC, the learned counsel for the petitioner submits that The said rule prescribes no period for filing a petition for appointment of commissioner. And in support of his submission, the learned counsel for the petitioner has referred to a decision of High Court of Madras in Sangmo Gathai versus Kamalamal, reported in 2017 to CTC, page number 353, and also of a decision of High Court of Orissa High Court in Narayana Manjari Sahu versus Rajkishore Sahu, reported in 2017 AIR Orissa 52, page number 52. But having heard the submission of learned counsel for the petitioner, I have carefully gone to the petition and the documents plus on record, and also perused the impugn order dated 19/8/2024. 19/8/2024. It appears that while dismissing the petition filed by the petitioner, being petition number 517 of 2024, the learned trial court has dismissed the same only on the ground of being filed at a belated stage. But it is well settled that delay in filing the petition is not a ground to dismiss the same. Not a ground to dismiss the same. Thus, having examined the impugn order in the light of the provision of order 26, rule 9 of the CPC, and also in the light of the decision of Madras High Court in case number so-and-so and of Orissa High Court in case number so-and-so, this court is of the view that the impugn order dated 19/8/2024 fails to withstand the legal scrutiny, and accordingly the same stands set aside and quashed. It is provided that the learned trial court shall appoint a commissioner to demarcate the plot of land showing tag number 764, 768, 769 covered by periodic patta number 46, 190, 234, and 2Z tag number 30 covered by patta number 78, tag number 762, which is allegedly govt khas land of Dholpur Revenue Circle, and thereafter proceed to hear and dispose of the suit in accordance with law in terms of this PIO is disposed of at this point.
Item 12.
Matter regarding what is not entertained to file this case also.
Pardon?
Petitioner is not entertained to file this case also, because it is a partnership file. There are 6 already partner is there. They just represented one of the person, we can say. According to law, it is not entertained. Let's kindly see page 10 also.
The person who instituted the case is not the partner.
But not partner also.
Okay, let notice go at this instance.
Law is very clear, Lordship. In partnership, like Lordship, kindly see page section 69. Subsection 2, Lordship. No suit to enforce a right.
Section
69, Lordship. Section 2.
No suit to enforce a right arising from the contract shall be instituted in any court by or on behalf of a firm against any third party, unless the firm is registered and the person suing are or have been shown in the registered firm as a partner in the firm. So he is not partner. Very clearly, he is represented by one.
Where is the partnership deed? Have you enclosed the same with this petition?
Lordship, partnership deed I not found, but Lordship kindly see.
No, unless you submit the partnership deed, how can we ascertain that he is not a partner of the firm?
Lordship, it is clearly in cross Lordship. Page 16 Lordship. Page 16,
Hmm.
name Chandan Kalita, son of Baneshwar Kalita, so and so. But I am a accountant of Suresh Enterprise. Suresh Enterprise is a partnership firm Lordship. He said, I am the accountant. And I have been authorized by one of the partners, Sumit Bajaj. But the other 5 partners have not given any consent to institute this case by me. Only one partner can give authorize. According to law, he may be partner. Without partner, nobody can. Third party cannot sign. He is third party Lordship.
You produce the partnership deed. We will consider it on next date.
Partnership deed.
At what stage the suit is pending now? At what stage the suit is pending?
Suresh Enterprise. Also,
How many witnesses are examined?
only one.
Only one.
He is just Chandan Kalita.
Okay, okay.
That's why
But
when I did know that he is the Chandan Kalita is not partner, then I filed a petition Lordship,
hmm,
under order 7, rule 11, page 21.
hmm.
To reject the claim. So without proper format, how can we continue the case Lordship?
Hmm?
Without proper format, we cannot continue the case Lordship. That's why we filed there.
Say you produce the partnership deed.
Give me time some
Hmm.
after vacation.
Heard Mr. Alamgir, learned counsel for the petition. In this petition under Article 227 of the Constitution of India, read with Section 115 of the Code of Civil Procedure, the petitioner Subroto Ghosh has challenged the correctness or otherwise of the order dated 13/2/2024 passed by the learned Civil Judge Junior Division number 1 Kamrup M in petition number 1615 of 2023 arising out of money suit number 228 of 2022. Notably, wide impugn order, the learned civil judge Junior Division, Kamrup M. Guwahati has rejected the petition filed by the petitioner under Order 6, Rule 11 of the Code of Civil Procedure for rejection of claim of the money suit number 228 of 2022. Pero having heard the submission of Mr. Alamgir, learned counsel for the petitioner, it is provided that Mr. Alamgir shall produce the partnership deed before this court on next date. List the matter
On 30 October. For admission, item number 13.
First of all, last within the other side took time to file affidavit in opposition.
Nobody is present today, Pavel?
Sure. Application.
For the section. Okay, after some time.
Item 14. Item 14.
Item 14, Lordship, there has been some delay on our part, Lordship, in filing our affidavit, Lordship. Lordship assured us it will be filed by 21st, Lordship. Lordship will take up
21st
the-
of
I appear for the state response.
21st of
October, Lordship. We'll file it the 21st of October, Lordship.
When the affidavit has to come from respondent number 6 and 7, my lord. My lord, kindly record may be called for, my lord. In this case, I have challenged the selection process, my lord, and selection process of the respondent number 8, 9, and 10, 8, 9, 10, 11, my lord. It is recordably necessary, my lord, because those allegations. It's a matter of 2022, my lord. Selection process of
heard Mr. Your good name?
S. Das.
As thus learned counsel for the petitioner and Mr.
I'm in bottom, Lordship.
Learned counsel for the respondent number,
1 to 7, Lordship.
respondent number 1 to 7. Come this side.
Respondent number 10 and 11. And I
Respondent,
have filed my affidavit already.
respondent number 10 and 11.
11.
You have filed your
I have filed.
affidavit in opposition.
Yes.
The learned counsel for the respondent number 10 and 11 submits that he had already filed the affidavit in opposition. Learned, on the other hand, learned counsel for the respondent number 1 to 7 submits that he may be granted some time to file the affidavit in opposition. Fair is accordingly allowed. Rest shall list the matter on October, so as to enable the learned counsel for the respondent number 1 to 7 to file affidavit in opposition. The learned counsel for the petitioner submits that the entire record of the selection process may be called for. No,
Okay,
the
to
respondent
petroleum-
authorities may be directed to produce the entire record of selection process before this court. Yes, what is your submission?
With
Lordship, I'll file my affidavit by 21st October, Lordship.
And the
That
record?
affidavit you file, Lordship, you can file the reply and then while Lordship may call for the record, Lordship.
in the meantime, records may be called for, my lord. Even if they don't file my lord, the affidavit, records from records, the matter may be disposed of, my lord.
Lordship, we'll file it by 21st, Lordship. Lordship can record this.
Okay, call for the record in the
Yes.
meantime. Shall produce the record of entire selection process before this court on next date.
Selection
List
process- my
accordingly.
lord, selection process pursuant to petroleum engineering, my lord, department.
Person to petroleum engineering.
Yes.
Okay.
Also,
Lordship, here I have received instruction, I pray for some time to file it.
Okay.
For SSA, I am doing that.
Heard Mr. P. Ahmed, learned counsel for the petitioner. And also heard Mr. Suduri, learned standing counsel for the SSA. For respondent number 5 and 6,
Yeah.
and Mr. Talukdar for respondent number 1 to 4.
One to 4 months.
Okay. Mr. Soduri submits that he has received instruction and he may be granted some time to file affidavit in opposition. Where is accordingly allowed, recessal is the matter on when?
Lordship, on reopening.
On 28 October. Number 15. 15.
In this case, I also pray for some time to file our affidavit, my lord. Lordship,
In item number 15.
15, my lord.
15.
Okay. If in this case, Lordship, the petitioner is not getting salary from March 2015, in spite of having the court's order. And in the meantime, he retired in January 21, Lordship. But last occasion, on the 28th of August 2024, they took time. And this case is pending for 1 year. Neither he is getting a salary and pension, Lordship. My prayer, Lordship, let them file an affidavit, give a last chance and a fixed date so that they can file and I can file the counter, Lordship. That objection may be given,
Okay,
Lordship, with the last chance.
heard Mr. S.U. Ahmed.
Yes, Lordship.
Learned counsel for the petitioner, and Mr.
B.
B. Talukdar, learned standing counsel for respondent number
1, 2, 3.
1, 2, 3. And Mr.
B. Sharma for respondent number 5.
B. Sharma for respondent number
5.
Five.
Accountant General.
for respondent number 5. You file your affidavit in opposition? Not necessary. Mr. Talukdar, learned counsel for the respondent number so submits that he has received instruction and he may be granted some time to file the affidavit in opposition. At this stage, so Mr. Ahmed, learned counsel for the petitioner, submits that
On
the
28th,
case is pending since the year 2023, and the petitioner has already retired from service, and
January 21.
he has January
21, Lordship.
January 2021, and since then he has not been receiving any retirement benefit
As well as pending salary, Lordship.
as well as spending salaries, and therefore Mr. Ahmed submits that last chance may be given to Mr. Talukdar to file counter affidavit. Accordingly, it is provided that last chance is given to Mr. Talukdar to file his counter affidavit. List the matter on
30 October. 30 October.
Yes.
Item number 16.
This is the first appeal, my lords, under section 96. Is the judgment and decree dated 5/8/2024, passed by the learned civil judge, senior division, Solitary. Now, my learned friend is appearing for the caveators, and we have served the copies of the appeal and the injunction application, stay application.
caveat or part. Caveat is not this.
Your Lordship, as regard the appeal, I have nothing to say, Your Lordship, it has to be admitted. Only as regard the IA, that is the stay petition, I have something to say, Your Lordship. I have objection to it, Your Lordship.
If the appeal is to be admitted, because order has to be passed under order 41.5, because the execution case is already proceeding.
Execution case file.
Yes, and I have annexed the copy of the notice in the IM.
I have deposited the balance consideration also, Your Lordship, the balance consideration of 7 lakhs.
My humble prayer as of today is that the appeal may be admitted and may be taken up for hearing according for the records. So the records also are necessary.
Heard Mr. Ganguly, learned counsel for the appellant, and Mr. Procedural, learned counsel for the respondent. There is only one respondent,
Yes, Your Lordship.
sole respondent. This appeal under section 96 of the Code of Civil Procedure is directed against the judgment dated 38/7/2024 and the decree dated 5/8/2024, passed in title suit number 48 of 2018 by the learned civil judge senior division Sonetpur in Taspur. It is to be noted here that by the impugned judgment dated so and so and decree dated so and so, the learned civil judge senior division has decreed the suit. On contest with cost by holding that the respondent stroke plaintiff is entitled to get a decree for specific performance wherein the defendant is directed and directed the defendant to execute registered sale date on receiving balance sale consideration amounting rupees 7 lakhs. Where is the memo of appeal and the grounds mentioned therein? Then also, where is the impugned judgment and decree dated so and so so and so? Admit, issue notice to the respondent. However, no formal notice is required to be issued since Ms. Procedural learned counsel entered appearance and received notice. However, extra requisite copy of the petition be furnished to him during the course of the day. The SSL call for the record from the learned trial court. List the matter after 4 weeks.
Your Lordship, as regard IA stay petition, Your Lordship, I have something to submit, Your Lordship.
Yes.
Your Lordship, I kindly see order 41 rule 5. If you see, Your Lordship. Order 41 rule 5, Your Lordship, subsection 1. An appeal shall not operate as a stay of proceeding under a decree or order appeal from except so far as the appellate court may order. Nor shall execution of a decree be stayed by reason only of an appeal having been preferred from the decree. But the appellate court may be on sufficient cause order stay of execution of some decree. Next, Your Lordship, sub-rule 2, stay by court which passed the decree. Where an application is made for stay of execution of an appealable decree before Your Lordship, where an application is made for stay of execution of an appealable decree before the extension of the time allowed for appellate therefrom, this court, the court which passed the decree may, on sufficient cause being shown, order the execution to be stayed. Then Your Lordship, subclause 3, no order for stay of execution shall be made under sub-rule 1 or sub-rule 2 unless the court making it is satisfied. Finally come to clause C, that security has been given by the applicant for the due performance of such decree or order as may ultimately be binding upon him. So, Your Lordship, undertaking some security may be deposited, Your Lordship, and even if your lordship stays the operation, your lordship, and then your lordship may kindly see that the rights, no third party interest is created in favor of any third party and status quo may be maintained, your lordship. Because if I have already paid out of the entire consideration, 15 lakhs was paid in the year 2017. And the balance consideration of 7 lakhs has also been deposited before the court below on in the execution proceeding, your lordship. So that aspect of the matter can be considered, your lordship.
Reply to what my learned friend has said, I have no difficulty in early disposal of the appeal. Maybe taken up for hearing as soon as the record comes. As far as security is concerned, my lord, and as far as my learned friend's apprehension that third party right will be created. No, a decree has been passed against me. Lordship can only stay the decree. My lord. The rest of the matter is mispendence. My lord. I cannot possibly, my lord, create any third party interest in that. Because as far as mispendence is concerned, my lord, everything will go.
In that case, your lordship will pass
that-
the order.
that apprehension of my
Nothing will
lordship-
happen if the direction is given.
No difficulty to that. There's no difficulty. If any status quo order is passed regarding the property, subject property in question, there's no difficulty. It may be made that without leave of the court, any third party interest will not be taken.
No, if I have to pass the status quo
No.
on whose pair? Your pair?
For that, he has to make a specific claim. That is exactly.
Your lordship,
that is
I have
exactly-
just shown the, your lordship, I have just.
Without
that's
there
unfair
being
provision.
an application.
No, your lordship, I have, that is why I am coming to order 41 rule 5, your lordship, rule 6. Even if your lordship says order 41 rule 6, your lordship, sub rule 2, your lordship, where an order has been made for the sale of immovable property in execution of a decree and an appeal is pending from such decree, the sale shall on the application of the judgment debtor to the court, which may make the order be stayed on such terms as to be given security or otherwise, as the court thinks fit until the appeal is disposed of. So your lordship, as per the provision of this CPC, your lordship may pass such order, your lordship.
These sort of orders are generally passed in case of money decrees, where they.
The lordship
Yes,
there-
exactly.
These sort of orders are not passed when immovable property is involved. And as far
Your
as
lordship,
third
there
party.
is no harm in giving the status quo order.
Caveat, my lord,
Otherwise,
my
third
learned
party
friend
right
is
may be
seeking to
created
argue
and-
the case with
Sorry,
caveat,
sorry,
that is
Mr.
not
Procedural.
permitted. It's not done.
Your lordship, then the liberty may be given with regard to the application, filing of an application, your lordship.
That they are free to file any application, my lord. No such liberty.
There
is
will be no
required.
harm if the
I
court.
don't understand, my lord, why all this is being said at the stage of caveat. At the stage of caveat, my lord,
Your lordship, I have no objection as
does
regard
not
to
have
the
a right to oppose the
admission of the
application
appeal, your
This is not
lordship.
fair, my lord. At the
Section
right of
144
admission.
is always there, your lordship.
No, my
Mr.
lord.
Procedural, one by one.
No, at the stage of caveat, my lord, my learned friend does not have a right to oppose the admission of the appeal also, even in the case of first appeal also, my lord. At the stage of admission, it is between the court and the, my lord, the appellant. And whatever terms are to be put, my lord, that is in the discretion of the court. And this is not a money decree, my lord, where 50%, 20% will be direct.
Okay. Heard Mr. Ganguly, learned counsel for the applicant, stroke appellant, and also heard Mr. Procedural, learned counsel for the respondent, stroke opposite party. This application under Order 41, Rule 5 of the Code of Civil Procedure, read with Section 151 of the Code of Civil Procedure, is preferred by the applicant for staying operation of the judgment and decree dated 38/7/2024 and 5/8/2024 respectively, passed in title suit number 48 of 2018, passed by the learned Civil Judge Senior Division Sonitpur, Tezpur. And also to stay further proceeding of title execution case number 34 of 2024 pending before the learned court of Civil Judge Senior Division Sonitpur, Tezpur, arising out of title suit number 48 of 2018. Mr. Ganguly, learned counsel for the applicant, submits that the applicants have preferred an appeal against the judgment and decree dated 38/7/2024 and decree dated 5/8/2024 respectively in title suit number 48 of 2018. and the same has been admitted by this court today, and notice has also been issued, and the record has also been called for from the learned trial court. And in the meantime, the respondent, opposite party, has already started title execution proceeding, being title execution case number 34 of 2024 before the learned civil judge, senior division, and unless the said title execution proceeding is stayed along with the decree, judgment and decree dated 30/7/2024 and 5/8/2024 respectively, the appeal would be in praxis, and on such ground, Mr. Ganguly contended to stay the judgment and decree, stay operation of the judgment and decree dated so and so, and also to stay the title execution proceeding number 34 of 2024. Whereas on the other hand, Mr. Procedural, learned counsel for the respondent, has vehemently opposed the petition and submits that unless security is deposited with the court, such payer cannot be granted. Having heard the submission of learned counsel for both the parties, I have carefully gone to the application and the documents placed on record, and also peruse the impugned judgment and decree dated so and so, past in titles of numbers so and so. It appears that the appeal has already been admitted for hearing, and the record has also been called for. And further, it appears that title execution proceeding has already been initiated before the learned executing court. In that view of the matter, this court is of the view that the impugned judgment and decree dated so and so and the execution proceeding dated so and so required to be stayed in the interest of justice. Accordingly, the same instance is stayed. In terms of above this, I is disposal.
Your Lordship,
Period disposal of the appeal.
Your Lordship, as regard the status quo, at least that order may be passed, Your Lordship.
Sorry.
Your Lordship, then we may be given the liberty, Your Lordship. Otherwise,
Item number 17.
Giblio.
May I please, Your Lordship? Under this, the repeal and the order of procedural rule 1D of the CPC matter, the first appeal against order matter. Your Lordship, in this case, Your Lordship will remember last time it came up matter, Your Lordship direct us to tax the first title matter, according to the same will be done matter. Here, matter, what happened, judgment for matter, decree procedure, etc., decree passed against the expert. Now, my lapse is also there, matter, the eligibility. Now, decretal amount is 35 lakhs against me. My case is that out of 35 lakhs, I have already paid them 31 lakh. Now, if decree is executed, my lord, serious injustice will be done, my lord. The documents I have annexed, my lord. That suit was filed by the suppressing material filed by the respondent. Out of 35 lakhs, he already received 31 lakhs. His receipt I have annexed, my lord. So, but we could not get opportunity to place this before the trial court below, my lord, because when we filed application under order 9 rule 13 for setting an expiry degree, there was a delay of 558 days. That has not been considered, my lord. Let's just say our party is also there, my lord. But even then, my lord, the land council in the trial court also, they have also faulted, my lord. The trial court judgment also, my lord, must be desired, my lord, page 72 LHR 11, my lord. He been finding, my lord, on rejecting my application, my lord. Page 75 would do, my lord. We have from 6 and all, we have for further scrutiny, the entire petition reveals the petition omitted to provide adequate explanation for total duration of delay. The date of knowledge rationale behind the request of coordination of delay of 550 days. Petitioner also attributed his inability to instruct his legal counsel to the COVID-19 pandemic, have a review of case record of title execution number so indicates that execution proceeding commenced on 21/8/2019 with a subsequent notice being issued to the judgment debtor, that is us, my lord, on 27/9/2009. Furthermore, petitioner was represented by his counsel on 11/12/19.
Mr. Sodori, at what is this? The execution case is pending at
Execution by reissued, my lord. Reissued.
when the next date is fixed.
2/11 now. 2/11. No.
Okay, let the record come, we will see.
Yes. Yes.
Heard Mr. Sodori, learned counsel for the appellant. This appeal under order 43, rule 1D of the Code of Civil Procedure is directed against the order dated 28/6/2024, passed in Missouri case number 11 of 2024, filed for condonation of delay of 558 days in filing the petition under order 9, rule 13 of the Code of Civil Procedure in title execution case number 38 of 2019. Arising out of title suit number 136 of 2018. It is to be noted here that by impugn order dated so and so, the learned civil judge senior division number 1, Kamrup M. Guwahati, has rejected the petition filed by the appellant. Peruse the memo of appeal and the grounds mentioned therein. Let notice be issued to the respondents, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Call for the record. Call for the scan copy of the record from the learned trial court. Place the matter after 4 weeks. Interim pair will be considered on next date.
All right, your number 18.
May it please the lordship. Lordship, item number 18 and 19, both a similar matter, can be taken up together, lordship. Perhaps, lordship, the respondent number 6, they will be placing some instruction before this honorable court, and he has requested me, he is in lakes in another court. Can it be taken up after some time, my lord?
Okay.
Oblige, lordship.
Item 20.
In this case, we have received our instruction, my lord. And as per our instruction, the petitioner is a irregular and illegal teacher, my lord. So lordship may take into consideration this instruction, or lordship may allow me some time so that I can bring on record, my lord. Let them file affidavit, lordship. I can respond.
Mr. S.A. Ahmed, learned counsel for the petitioner. And also heard Mr. B. Talukdar, learned standing counsel for
Elementary education.
Elementary education.
Phone number 1, 2, 3.
Respondent number? Your good name? AZ. And Ms. So learned counsel appearing on behalf of S.K. Medhi, learned standing counsel for the respondent number 5. Mr. Talukdar submits that he has received a written instruction and he may be granted some time to bring on record the said written instruction. Pair is accordingly allowed. Recessal list the matter on when?
On 4th November. 21 and 22.
As per last order, my lord, the state respondents are supposed to respond by filing a written opposition. They have not yet
Still
filed.
awaited, my lord. Taking up after vacation, my lord.
No, Mr. Khatonier. On the other day, one Ms. Terangpi appeared and she submitted that she has received instruction, and today you are submitting that you have not received any instruction. What is this?
Well, I have checked in the, we have a group, my lord. I have checked that I could not find the instruction. Maybe today, in fact, brief is not here, my lord. I have checked in my group, my lord, that instruction is not there. So
Then on what basis the learned council on the other day
maybe, my lord,
submits
maybe, my
that,
lord, in file today, my lord, we have, I am sorry to say, my lord, today brief is not here, my lord. So, maybe in the file.
no, that's all right.
Instruction is there.
Your brief is not here today. We'll grant you time.
Yes, madam.
But we are concerned with the submission made by the council on the other day that she has received instruction, and today the instruction is not received by you.
Because,
What is this?
because I am not aware of that, my lord. That is why, my lord. In fact, in the maybe in the file instruction is there, she was aware of that, but I'm not aware of that, my lord, since the brief is not here. I have just checked with in my group, my lord, so I could not find it. My lord, we take it up after vacation. If it is there, definitely we will file it. If it is not there, I will obtain the instruction and I will file it, madam.
Heard Mr. B. Purkaisto, learned counsel for the petitioner, and Mr. Khatonier for the respondents. Secondary education. Mr. Khatonier submits that he has not received instruction and prays for granting him some time to obtain the instruction and to place the same before this court. However, order dated 13/9/2024 indicates that on that day, Ms. Taran P. H. Taran P., learned government advocate, appeared for the respondent and apprised this court that she had received instruction and she will be filing counter affidavit in this petition. But Mr. Khatonier today submits that he has not received instruction. However, list the matter on
25th October.
25th, so as to enable Mr. Khatonier to place on record the instruction he had received or no, he will be receiving from the respondents.
My lord, and two requisitions are there, and filed by my lord, the petitioner of item number 22, my lord, the WPC 213624 and 391724. These two items was met together. WPC
And,
2136.
same order is to be passed.
Yes, yes, because they were tagged together.
What are the numbers?
My lord, WPC 213624 and 391724. These items that are filed by the petitioner of item number 22. This case may be tagged together.
Okay. You give the number to.
Yes,
court,
I'm giving.
Okay.
Item 40.
Please, Lordship, as per
Yes.
last direction, my lord, the RIMC authorities were supposed to
I'll
produce the instruction.
apprise this court about the instruction.
Yes, my lord.
But Mr. Gupta is absent today. Okay, Gupta. Okay, after some time, in the meantime, court master will inform him.
Yes, my lord. My lord, sorry to say, my lord, in second half, my lord, I have some difficulty, my lord. Please, my lord. If
No, as soon as Mr. Gupta is available, we will take it up.
yes,
Wait for some time.
For bail hearing, item 24.
Kindly will take it to my lord, B. Sharma has gone from these in election another court.
Who?
Bidut Sharma. At two.
You have received the case diary.
Case very well.
Items for hearing under order 41 rule to CPC. Item 25.
Thank you, Your Lordship. My lord, this is the second appeal. My lord, the factual matrix of the case is that one Kaliram Das had two wives, my lord. Premadabara Das and Virenabara Das. Now, my lord, so far the first wife is concerned, there was no issue from that. and Birendra Baladas had 2 sons and 3 daughters, my lord. And so far, these two females are concerned, my lord, who are the wife of Kaliram Das. In their joint name, they purchased the property measuring 4 kattha, my lord. Out of that, my lord, 1 kattha was given to the daughter's husband, my lord. Second daughter was Srimati Urvashi Das. So his husband was Mr. Brajendra Nath Hajalika. To him, it was given by way of gift, my lord. After that, another plot from the same plot of land, my lord, measuring 1 kattha 6 rickshaw was given to him in the year 1978. In the same year, my lord, the two ladies created a gift in favor of their third daughter, Gunada Baladas, with certain conditions, my lord. My lord, I would like to take your lordship to the conditions which are appearing at page number 23, my lord. Sorry, my lord, it is at page number 29. 29 is the start, but the conditions are at page number 30, my lord. Just down below, my lord. The relevant conditions incorporated in the gift deed.
Okay, let notice go at this instance.
My lord, caveat is already there, caveator,
Yes.
when he is already there. So let the appeal be admitted, my lord, with the substantial question of law, my lord, which is already there at page number, your lordship will be pleased to find at page number 23. The substantial questions of law are there, my lord. Only 2 substantial questions of law are most important, my lord. Page number 23, my lord. 11, Roman 11, Roman 12. Because so far the condition number, substantial question number 13 is concerned, my lord. In the cross-examination also they have admitted that they are abiding by. Out of the 4 conditions, my lord, they are abiding by only 1 condition, and relinquishing 3. So where the only substantial question of law, according to me, my lord, is whether section 10 creates any absolute restraint on the transfer, my lord, or it is partial. If it is partial, my case is there, my lord. If it is absolute, then I don't have any case. So let the appeal be admitted, my lord, on these 2 substantial.
Yes, Mr. Sarma.
That the lordship has to see, it is very small matter, which your lordship can see, whether both the court below have rightly come to the conclusion that the gift deed, one of the terms of the gift deed, if the condition number 3 was hit by section 10 of the transfer of property. Yes. That is the only thing. So the court, this court can definitely see whether the trial court and the first appellate court has rightly come to the conclusion. If they have rightly come to the conclusion, in that case, there is no substantial question of law involved in the appeal. So, my lord, if we allow this appeal before considering this matter, in that case, if after 10 years, appeal will come out hearing and the parties will be locked to their appeal. That is the main problem. So, I think that has to be seen whether both the court will have rightly decided or wrongly decided. That has to be looked at. Otherwise, only for that matter, after 10 years, the court will say that your trial court has rightly decided. In the meantime, I am the person who has purchased the land. And
That's all right. What is your submission now?
So my submission is that. My submission is that. My lord, in fact, there is no substantial law of law involved in the appeal. My lord, if it is, even time of it is same.
Okay, then you come prepared. We'll fix it
after
vacation. Yes.
After vacation, it will be fixed on
Yes, my lord.
Okay. Heard, Mr. Will not admit it today.
Oblige, your lordship.
Heard, Mr. S. Akhtar, learned counsel for the appellant, and Mr. Sharma, learned counsel for the respondents. After hearing learned advocates of both the parties, it is provided that recessal is the matter on 28.
Finding 40
I have received certain instructions, my lord,
Yes,
regarding the vacancy which may be created by a candidate, my lord, who is withdrawing. My lord, that will not give him a right for admission because course has already started. If any candidate, my lord, withdraws, that will subsequently make up a vacancy. That is what my instruction is. In between the court, for example, my lord, 28 candidates are selected and they have been admitted. Now, if any candidate does not want to continue the course, that will create a vacancy for future admission, but the process cannot be reversed back to take admission of a student. My lord. That is the selection process. My lord.
no, when the course is started,
Course has already started. My lord.
when?
14th of August, maybe last admission took place.
Second admissions are also about to, for the second year, 2024, also admission process has already started.
That's all right. But if the classes are started in the
Last admission, my lord, second batch was taken to my information, my lord. It was on 14th of August.
14th of
14th of August. And my lord, as the vacancy has arisen, my lord. So,
And
my
regarding the
admission may be considered, my lord.
regarding vacancy, my lord, I have received a communication how the vacancies were, my lord, formulated. Page 3, my lord. My lord, boys and girls, they are different categories. Lord, it is stated that the strength of boys cadets at RIMC is 233 against authorized strength of 250. White Government of India Ministry of Defence letter number dated 5 October 1983. The details of strength are tabulated as under. Present strength 233 plus 1 234. Pending admission nil. Passing out in May 24, 23. Likely withdrawal 3. Net strength after A plus B minus C plus D is 207. Boys pending vacancy 43. And then finally, at serial number 5, recommended vacancy. Recommended vacancy for July term 24 is 28 plus 7. It is 28 boys and 7 girls.
So, since the beginning of the classes, only 1 month elapsed. So perhaps he may be.
As on date, there is no vacancy. 28 vacancies all are filled. And that students, that specific information I have not received whether somebody has withdrawn.
No,
or
that
not.
was the direction of this
Yes,
court to obtain
mine.
instruction.
That specific instruction I have not received.
Yes,
Whether that particular
on the
candidate.
other day, we have asked you to obtain the specific instruction that whether any student left the institution or not.
That is Devan's
Devan's
of Madhya Pradesh.
mailed them on that day itself, 3 days back only. But I will place it by way of an affidavit, these additional document things which I have received. Tomorrow we will. I will
Our
file it.
requirement is whether anybody left the institution or not.
Yes.
That is specific instruction is necessary.
My lord. Well, I can come back at 2, my lord.
2.
No, my lord.
Okay.
Well, 2 I have. Personal
Difficulties.
difficulty, my lord, today, my lord.
Then
Well, the
tomorrow?
play, my lord, subject to
Tomorrow?
convenience, my lord. Well, if it is on 4th, my lord. Well, I am going to Gwalpara in the evening, my lord. Tomorrow again, my lord, there will be.
Okay.
4th.
In the
Second
meantime-
is 2nd October is no court is there. So let it be on 3rd of October. So, yes. Thursday. 3rd.
Yes.
My lord, I would like to file an additional affidavit, my lord, placing.
You can, there is no bar.
My lord, I will file.
Liberty is also not required. You can
Yes.
file.
Yes.
Not only that instruction will come, my lord, they will provide. My lord.
Yes, yes.
That also I will state it in the affidavit only.
Okay,
My lord.
that will be fine.
Yes.
Both the councils are present. Mr. Gupta, learned counsel for the respondent submits that he has received some instruction, then he will place the same before this court by way of an affidavit. And price for granting him time here is allowed. Dismissal is the matter on third. And on that day, Mr. Gupta shall obtain specific instruction as to whether any candidate left the institution and whether any vacancy is arising out of the same.
26. Malad, it is, sorry, Malad, it is coming on 3rd of October.
Yes.
I'm obliged.
May it pleases your lordship, matter may kindly be adjourned for the day, lordship, as my senior Mr. S.P. Chaudhary is having some medical emergency, lordship. He is
On
suffering
the
from
prayer being made by Miss, your good name?
Miss B. Devi, lordship.
B. Devil, learned counsel for the appellant. Recessal is the matter.
Lordship, can it be on Thursday, lordship, because there is some emergency? Kindly, lordship, because
Thursday may not be possible.
then on Friday, lordship.
Friday.
Right. Deeply obliged.
Orders 27. In this case, my lord, on the last occasion, the other side, my lord, has informed that respondent number 2 has died, but they have not furnished any details of the legal heirs of the respondent 2. Unless legal heirs details is not given to us, I cannot find
They
any
have not
petition.
asked for any information. Today, when I came to know about the senior records, I asked them whether you have filed a petition or not. So it is not our duty to furnish any information. They have to ask us. It is their case, and there is no specific directions also. We can provide it. We can provide the details. And we are
Yes,
ready to-
provide the
Please
details.
provide. Why you are disputing? That is very
No,
surprising.
not see, they are taking the privilege. They are not even last order. They have not seen the order also. So in the last order also, it has been ordered that substitution should be filed. But till now, they have not filed.
How can I file unless we get the details of the legal
They are
heirs?
not coming to us, Lord. See, they should have asked. They should have asked in the last occasion.
Way of-
Okay,
I
now,
reminded-
now.
In the last
now-
occasion, I reminded them, Lord.
No,
You
no.
can furnish today.
Now
Now,
we-
now
Okay, I will file for this today. It is
Okay. You file today.
making unnecessary delay, Lord. See.
Heard Mr. Sigdar, learned counsel for the appellant, and Mr.
As a Bhakti.
S.A. Bhaktiyar, learned counsel for the respondent.
In the meantime,
Mr.
Lord,
Sigdar submits that he has not received the required information from the counsel for the respondent.
Lord, see, there is no specific direction also whether they have to.
No,
come-
I am recording his submission.
Lord, see.
He has not received details of the legal heirs of respondent number
2.
Respondent
Respondent
number 2, for which he could not file the impleadment petition. And price for granting him some time there is accordingly allowed. The learned counsel for the respondent is directed to furnish the details of the respondent, legal heirs of the respondent number 2 to the learned counsel for the appellant
Lord, see,
during the course of the day.
Lord, see, in the meantime, answer may be called for because second time reminder was issued.
My flag L may kindly have look, my lord.
As per office note dated 26/9/25.
So the LCR is not available there.
Transfer to some other code, my lord. Yes. That is
Due to
indicated by.
TDL jurisdiction.
Hmm?
Due to TDL jurisdiction, it has been transferred to Baksa district.
Transferred to Baksa
Baksa.
district,
Musalpur.
Musalpur. Where is the office note dated 26/9/2024? It appears that the record of title suit number 030 of 2012 is transferred to the court of district and district judge Baksa. Pursuant to a letter of this court dated 15/11/2017. Accordingly, it is provided that registrar shall issue, registrar shall send the requisition to the learned district judge Baksa for transmitting the record to this court without further delay. List accordingly. After 4 weeks.
28.
I am responding well.
May I please your lordship?
Yes.
I am an advocate. My name is Sunita Begum. My case number is case number 53/2024 in IA 351/2019 in test 3/05. This case is filed to admit for restoration of medical ground.
Are you petitioner in person? My lord, petitioner in person. The cause list shows that the petitioner in person is to appear.
Petitioner?
Petitioner in person. Petitioner is Abdul Matlib Saikia. He has taken the liberty from the Honorable Court to appear by himself before the Honorable Court, petitioner in person. And on the last date, my lord, he took the, liberty from the Honorable Court to supply me a copy of the petition which is filed by him in the year 2024, MC case number 53. Because the matter which is agitated now, long back it was dismissed in the year 2018, my lord, by Honorable Justice Suman Sam. That MC case, that my lord, if the record is there, 3/2005 is the testamentary case, my lord. It was dismissed in the year 2018.
So you were appearing on behalf of Abdul Matlib Saikia.
Then he shall have to give her Wakalatnama. Then he shall have to give her Wakalatnama.
Yes. Have you filed your Wakalatnama here?
Yes.
When?
Next week I will file.
She has not filed, she is saying that she will be filing on the next day.
Acha. Pardon me, your good name?
My name is Miss Sunita Begum.
Learned Counsel.
Yes.
Appearing on behalf of, appearing for the petitioner, Mr. Abdul Matlib Saikia.
Yes, my lord.
And she submits that she will be filing her Wakalatnama in next week. Also heard Mr. Sutter, Learned Counsel for the opposite party. Registrar list the matter immediately after reopening.
Like your lordship, but meanwhile, if they can give me a copy, my lord, that will be more proper because they have already taken on the last date the opportunity on 28/8/2024,
Okay.
my lord.
Whether copy is available.
Yes, yes.
The Learned Counsel appearing for the petitioner submits that she will furnish a copy as requested by Mr. Sutter, Learned Counsel for the respondent.
Yes, my lord.
During the course of the day. Today itself, you furnish it.
Yes.
Obligement.
Obliged.
It's in 1920 photo.
Meet with lordship. I
Yes.
seek indulgence, my lord. My lord, there is an IA for withdrawal, my lord. If it can be listed any date, my lord, to the convenience of this photo.
I for withdrawal.
Tomorrow?
Day after, on first,
Us.
on, okay, tomorrow. Tomorrow.
D block.
Item numbers 43 and 44 upgraded matter.
Your lordship. My lord, there are two criminal petitions with IA, my lord, two pending IA, my lord.
One is filed by the husband and one filed by the wife. And
Today was subject to right from Lordship. Today was fixed for obtaining instruction whether they have received that amount or not. And just one thing, if I may add, Lordship.
Yes.
After that also, we have instructed our client and he is supposed to deposit 20,000 as on today, but due to some problem, he could not. He said that tomorrow morning he will say deposit another 20,000 in her account. That is the, so I may be allowed some time to file our affidavit to bring on record those documents which we have already deposited 50,000. Another 20,000 he is supposed to deliver by deposit by tomorrow.
But whether that amount will be sufficient to undergo the treatment of her diseases in which she has been suffering from?
But at least we can initiate that medical treatment and submit documents before this court. If it is found that that is not sufficient, we'll deposit some other amount also. But at least he could submit those documents also that he has initiated.
But as submitted by him, the arrear amount is more than 10 lakhs rupees.
No, that is not the case. Lordship, if your Lordship say that initially there was direction to pay 14,000 per month, which was modified by the learned session judge to the tune of 12,000. So it has to be calculated from 12,000 because still that session judge order is in existence, Lordship. Because that order your Lordship has not set aside till date. Only that was still. The amount which was initially there was there that was 4 lakhs something, Lordship, when the stay order was passed. Subsequently that has increased. So for considering that, please Lordship, that 4 lakhs will come because after that stay order was there. So from 4 lakhs already 50,000 we have paid, and now Lordship 50% we have already paid, and after that Lordship we have paid 50,000, and as per instruction 20,000 will be paid tomorrow. So it will be around Lordship 3 lakh, more than 3 lakhs out of that 450 that initial when your Lordship granted stay order that 4,92,000 was there, and your Lordship directed to pay 50% we have already paid, and after that 50,000 and 20,000 yet to be paid. So around that will be paid.
Okay, you file your objection.
My lord, kindly I may be heard, my lord. Thing is that, my lord, even if my learned friend accounts the 12,000 per month area, forgetting 14,000 ordered by the trial court, till it is 9 lakh plus pending to be paid. I have given the account in my IA. Number one. Number two, my lord, I'm not going to merit now. What happened, my lord? Because of forceful termination of second pregnancy because of female child.
No, we are not on merit now.
My lord, I'm medical.
We will hear you.
What is the medical condition, my lord? Then your lordship will be able to appreciate the necessity of how much, my lord. Then, my lord, kindly see some medical documents I have annexed. See, if my ureterus cystitis needs operation pending for so many years, my lord, so many months, my lord, which she could not. Kindly see series of documents, series of test reports. The child who is now going to school, my lord, he also needs, my lord, my maintenance, my lord, the school fees, my lord, feeding and medication. She has lost one her eye because of typhoid. Even at the time of typhoid, my lord, he has not come to see him, not a single repeat, my lord. He has lost one of her eye, both of her. I said hearing aid is lost, my lord, to some extent, not entirely, my lord. Now, 3 loans have taken from private person. I have annexed all the documents, my lord. 2 loans of gold ornament, one of her own name and one of her mother, depositing the gold ornament, my lord. Now he has to pay the interest, my lord, and the got for medical expenses. Then go for the operation of the child and operation of her, my lord, and of child education expenses, medical expenses, all are pending for long maintenance. I have sold 5.5 bighas of land of my father. I have the details given in my assets and liabilities, my lord. Nothing to sell more, my lord. In a critically condition, my lord. Just suffering from depression, medically recorded, my lord. I can show your lordship. The depression suffering from serious depression, my lord. It's the situation. He has told, I will make you mad and will not give you single penny. It is recorded long back, not now, my lord. It is in the court proceeding, lower court. He has said in the open, my lord. So under the circumstances, at least he would not pay this area amount, my lord. 50,000, 70,000, nothing, my lord. Nothing will happen, my lord. And number 2, my lord, your lordship will be strange to know that the trial court could not get his income, my lord, and assets The divisional court could not, my lord. They have decided only on the basis of 34,000 salary, my lord, given to 14,000, then 12,000. Both the courts recorded there that they could not get any document, my lord. Even I being a wife, was not aware of the amount of his salary. Now he's getting 81,000, my lord, only from salary source. Other fisheries, because he has even suppressed the amount of salary in his essential liabilities affidavit, my lord. It is a suppression affidavit, my lord, as if, my lord, we have to help him. This is the case made in the affidavit, my lord. Such a situation he has created, my lord. And actually, he is having income not less than, my lord, 2 lakhs, my lord, per month from all the sources, my lord. And now, my lord, the Supreme Court has repeatedly, my lord, ruled that if such suppression is there, your lordship has all the power to strike off and to give order, my lord, on the basis of documents of your lordship. And I will file affidavit also, my lord. How he has suppressed, he has own building, RCC building, all suppressed, no paternal property. Even the salary he has suppressed, my lord.
Learned counsel for the respondent. Learned counsel for the respondent. Pursuant to order dated 27/9/2024, Mr. Talukdar had obtained necessary instruction. Press this court that the applicant has received a sum of rupees 50,000. Mr. Ahmed, learned counsel for the respondent, submits that the respondent will deposit another sum of rupees 20,000 by tomorrow. By tomorrow.
My lord, kindly, small prayer, my
And
lord.
submits that on next date he will file an affidavit in this regard. However, having heard the submission of Mr. Talukdar, learned counsel for the petitioner, the applicant, and also considering the ailment in which the applicant is suffering from, as it appears from the documents enclosed with this application, it is provided that the respondent shall deposit another sum of rupees 50,000 within a period of 2 weeks from today. 2 weeks from today.
2 weeks from today. That was
And thereafter submit an affidavit before this court. List the matter on 20.
On 14 November.
So that
it's too long, my lord.
7 November.
Maybe in October, my lord.
24th October.
My lord,
50,000, including that 20,000, that which he is supposed to.
My lord,
that may be observed, Lord.
Not necessary.
My lord, 2 bank loans, my lord, 3 private loans, my lord, 2, my lord, 3 still medical care, the child, my lord, the educational cost, my lord.
Well, finally,
may be increased, my lord. Otherwise, my lord, it will, my lord.
No, anyway, he has to clear all the dues which you are entitled to.
My lord, as of
So you file affidavit, or what is the actual amount you are supposed to receive from?
My lord, that he will not deny, my lord, at least, my lord, if it is correct, my lord. I am, for the sake of argument, yes, he is 12,000.
No, there is no bar. If he clears,
Mr.
Talukdar, there is no bar in clearing the entire amount by him.
My lord, see, 2016 is not clearing, my lord.
Before your lordship to adjudicate, my application is still pending, which I have challenged both the orders. That is still pending. I do not know in which direction it will go, but that is still pending, lordship.
No, since 2016, my lord. 2016, my lord, kindly see. How many years, my lord, kindly see, my lord.
Okay, on next day, we will hear the matter finally.
On, my lord, 24th, my lord.
Yes.
Timing matter 24, bail hearing.
Bless.
May please, lordship. No, the FIR is page 13, relevant portion is page 13, madam. Complaint against Parthovatim, Bordoloi, Salam Ali, Hafizur Rahman, and others, madam. When main accused all are released on bail, madam. Parthovatim, my lord, Salam Ali, and so, madam, the petitioner also may kindly allow to go on bail. Other named accused shall be released on bail.
So this is a first application or second application?
So first application.
First application.
But matter is Saddam Hussein, several Saddam Hussein here. One, Ator Ali, son of Ator Ali. My present Saddam Ali is son of Hamid Ali. He's from Zagiro. And another, Saddam Ali was there. He was from Lahori. Like that, others, Saddam Hussein also filed similar to one. Saddam Hussein also filed this other one from.
Yes, Mr. Soma.
My lord, I have received the case there, my lord. The allegation is that against my lord Parthopotim Bordoloi, Salam Ali, Hafizur Rahman, and others, my lord. All of them, my lord, created more than 700 fake Aadhaar cards, my lord, by submitting fake and fraudulent documents, my lord, by using the station ID card of Parthopotim Bordoloi, my lord. My lord, here investigation is going on, my lord, and some of the witnesses examined, my lord, and
Is there any material against the present applicant?
my lord, not found sufficient material, my lord.
Not
But
found sufficient
investigation is
material.
going on, my lord.
Okay, let him go on bail.
My lord, interim, my lord.
Heard Mr. B. Islam, learned counsel for the applicant, and Mr. B. Sharma, learned additional PP for the state respondent. Apprehending arrest in connection with Zagiro, please case number 9 of 2024 under section 120B for 2468 for 70 on IPC. This application under section 482 of the BNSS 19 BNSS 2023 is preferred by the applicant, namely Saddam Hussein, for grant of PRS bail. Notably, the above noted case has been registered on the basis of an FIR lodged by one sort of bundle on 5/1/2024. The gist of allegation in the FIR dated 5/1/2024 is that one Parthopotim Bordoloi is involved with fraudulent activities of issuing Aadhaar cards at Dhopguri Gaon Panchayat under Deputy Commissioner Kamrup N, and he prepared more than 700 fake Aadhaar cards by submitting fake and fraudulent documents, along with one Salam Ali, Hafizur Rahman, and others by using station ID -83125 of Parthopotim Bordoloi. Mr. Islam, learned counsel for the applicant, submits that the applicant is innocent and no way involved with the offense alleged in the FIR, and that he is ready to cooperate with the investigating agencies. And some of the co-accused have already been granted the privilege of PRS bail by this court, and maintaining parity with those applicants in AB number 797 of 2024, AB number 426 of 2024, and AB number 635 of 2024. Sir Islam contended to grant the privilege of PRS bail to the present applicant also. On the other hand, Mr. B. Sharma, learned additional PP, has produced the case that before this court and submits that the materials collected so far against the present applicant is insufficient to show his culpability with the offense alleged in the FIR. Having heard the submission of learned advocates of both the parties, I have carefully gone to the petition and the documents plus on record, and also produced the case diary with the assistance of Mr. Sharma, learned additional PP. In view of the submission of learned advocates of both the parties, and also considering the materials collected so far in the case diary against the present applicant, his custodial interrogation seems to be not warranted here in this case, and accordingly this court is inclined to allow this application. It is provided that in the event of arrest of the applicant, he shall be released on pre-arrest bail on his executing a bond of ₹50,000. Inspection of the arresting authority. The above privilege is, however, subject to the following three conditions. interconditional law evidence. In terms of above, this AB is disposed of, case will be written.
Timing matters 18 and 19
No, more.
for admission. May it please your lordship.
Yeah.
Lordship, item 18 and 19 both are similar matter.
Yes.
In fact, same impugned order.
Hmm.
Allowed order pertains to examination of MBBS examination, lordship, for students. Lordship, in the instant case, students are from Guwahati Medical College, lordship. My lord, we are aggrieved by the impugned order that your lordship will find at page 32. Impugned order. May I read, my lord? As per Medical Council of India, New Delhi Regulation on Graduate Medical Education 2012 of page 10, clause 7(a), a student shall not be allowed to graduate later than 9 years of joining first MBBS course, lordship. Lordship, at this juncture, lordship, I would like to submit before this honorable court is that Regulation 2012 is quoted here in this notification, lordship, but there is no such regulation of 2012, lordship, at any point of time. Therefore, lordship, quoting of regulation 2012 is irrelevant, my lord. My lord, the regulation which is in force as on date is regulation 2019, which is amended, lordship. Your lordship will find the regulation at page 44, annexure 7. Page 44 is the recent regulation under which I am being governed. The relevant portion your lordship will find at page 45, my lord. Page 45.
Yes.
Yes, my lord. May I read, my lord? A very short regulation. In exercise of power conferred by Section 33 of Indian Medical Council Act 1956, the Board of Governors in supersession of Medical Council of India, with the previous sanction of the central government, hereby makes the following regulation to further amend the regulation on graduate medical education 1997. Lordship, clause 2 will be relevant, my lord. Clause 2. The following shall be added as clause 1A to the regulation on graduate medical education 1997, subclause 1 of clause 2. The regulation of graduate medical education 1997 from clause 2 to 14 contained in chapter 1 to 5 and the appendixes and schedules appended therein shall be included as part on of the regulation. These provisions shall be governing regulation with respect to the batches admitted in MBBS course until academic year 18-19. Lordship, here the petitioner got his admission in the year 2013, and in item number 19, he got his admission in the year 2014. Therefore, Lordship, as per clause, subclause 1 and subclause 2, Lordship, I will be governed by a regulation of 1997. Subclause 2 of clause 2 is also important, my lord. Part 2 containing the following chapters shall be added to the regulation on graduate medical education 1997. That shall be the governing regulation with respect to batches admitted in the MBBS course from academic year 2019-20 onwards. Lordship, the student who get admission from 2019-20 onwards, there is a restriction of upper time limit of 10 years for completion of the MBBS course. That part your lordship will find at page 50, my lord. Page 50. Page 50, first line. 11.2.6. A learner shall not be entitled to graduate after 10 years of his joining of the first part of MBBS course. Lordship, this clause 11.2.6 is applicable to the students who gets their admission 2019-20 onwards. But to those students who gets admission prior to 2019-20, there is no upper cap limit. That aspect has been observed by this honorable court in several orders. One of the orders your lordship may peruse. Page number 51.
So, what is provided in the 1997 regulation?
Yes, my lord. My lord, that part will clear, my lord, from page 54. Page 54. In 1997 regulation, there is no upper cap limit, my lord. It is prospectively implemented after 2019.
You are referring to page number?
Page number 54, para 5, order of this honorable court. Para 5. To a pointed query made by this court, Mr. A.M. Bora, learned senior counsel appearing for the National Medical Commission, as to whether there is any bar in respect of the petitioner to complete his MBBS course. Mr. Bora submits that Under the Graduate Medical Education Regulation 1997 as amended, a learner who has joined MBBS course prior to the year 2019-2020 academic session, there is no bar in completing the MBBS course. However, a student who had enrolled after 2019 and 20 academic session, there is a cap for 10 years for completing the MBBS course. Lordship, this has been the stand of the National Medical Commission in subsequent cases, my lord. My lord, exactly similarly situated case, very recently, this honorable court has disposed of two similar cases whereby the order of Guwahati Medical College and Jorhat Medical College has been set aside and quashed, lordship. Considering this stand of the National Medical Commission, perhaps it will be cleared by the respondent number 6. Those order will be relevant, my lord. WBC number 849/2024. That pertains to Guwahati Medical College. My lord, paragraph 7 and 8 will be relevant. Paragraph 7 and 8, page 4. May I read, my lord?
Not necessary in the same line, perhaps.
Exactly, my lord.
So you produced the 1997 regulation.
1997 regulation, lordship. Regulation, lordship, I have not annexed. It has been amended in the year 2019, lordship.
That's all right. You produced the regulation before this court. Because now you are submitting on the basis of submission of the standing council.
Lordship. Lordship, instruction were called for by this honorable court from respondent number 6. Perhaps they have received the written instruction, lordship. That may be considered, my lord.
Yes, Mr. Boydya.
Lordship, basically, what my learned friend has placed before this honorable court, Lordship, there has been a series of litigation pursuant from last year, my lord, with regard to candidates, wherein, my lord, that they are either on the verge of about 10 years from their first admission to MBBS, where matters like this had come up, my lord. So, in the outset, my lord, in one of the matters, NMC was called into, my lord, the aid of this honorable court. And my lord, we have confirmed from the concerned department as to what he has submitted, my lord, that, my lord, up till the year 2018 and 19, my lord, for whatsoever be the reason, there was no outer limit or a cap for completing, my lord, the MBBS course. Though surprising, my lord. In the year 2012, my lord, a set of guidelines were promulgated. But to the best of my instructions from my department, my lord, those rules were never gazette notified, my lord. My lord, if one searches on the internet, or my lord, at times communications were also made, but they were basically, my lord, internal guidelines or policies, but those were not implemented, my lord, from what instructions I have received. So, my lord, on seeking proper written instruction with regard to petitioners like the present one and 3-4 other, I think 2 of the orders have been placed before your lordship. Then, my lord, the written instructions have come specifically in each of the cases that that impugned order vis-a-vis only to the limit that if they have been barred only because they have crossed the limit of 10 years, then, my lord, that would not be applicable upon them. That if there are some other hindrances in them pursuing the course, then, lordship, the National Medical Commission would not be the appropriate party to comment. My lord, the other state respondents would be the appropriate authorities. As to how many times they have appeared in the same examination, or my lord, whatsoever may the cause be. But if the question to be put in perspective is that whether after completion of 10 years also can they pursue MBBS course, that they could not complete it within 10 years. And if the 10 years is the outer cap, then, my lord, 10 years is the outer cap only for students who have joined in MBBS course from after the session 2018 and 19, lordship. If the admission into MBBS
So,
is prior to
according to you, there is no upper cap for the students who have joined the course before 18 and 19.
Before 18 and 19, lordship, there may be other reasons for which they may be barred, but on the time limit, my lord, of being 10 years.
Okay. Who is for other respondent?
Other respondent, my lord, my lord, was just there, my lord. Lordship, I beg to place this on record. This may be kept as part of the record, my lord. The
My lord,
present petitions are
1997
mentioned.
regulation I have placed before this honorable court, wherein nothing has been provided regarding upper cap limit for the student, those who get admission up to 2019-20. And similar orders of Guwahati Medical College and Jorhat Medical College has already been set aside and passed, my lord, which I have placed before this honorable court. And the present petitioner is the 9th semester student. Only one paper remaining left, lordship, only medicine paper to qualify, lordship.
This, my lord, on the previous occasion, my lord, my learned friend for the state, my lord, the university, my lord, Srimanta Sankardeva University of Health Sciences, Mr. B. Gogoi and the learned counsel for the petitioner, my lord. They had a deliberation over this, my lord, and that was left to the learned counsel for the other department, my lord. That I would not be able to say what papers remain and as
Okay,
to if there any
Gogoi.
other reason also.
Health. B. Gogoi. So let Mr. Gogoi come.
Yes.
Lordship, lordship.
Item number 29 for us.
This is an application for transfer with divorce proceeding from the Honorable Court of District and Sessions of Udalguri to the Honorable Court of District and Sessions and Business Tribunal. You know, here the petitioner is the wife, you know. The respondent is the husband. He filed a divorce petition before the Honorable Court of District and Sessions of Udalguri, you know. I may point out, yes.
So you belongs to Bishwanath Sareli.
Business Sareli. Marriage was solemnized at Business Sareli. Respondent lives in Business Sareli. Petitioner and respondent last reside at Business Sareli. There is no cause of action at Udalguri.
Yes, madam.
As per section 98.
You are for respondent?
May I please, your lordship?
Yes.
We have filed affidavit in opposition today, so kindly the matter may be fixed after vacation. And regarding about jurisdiction, my lordship, that time the respondent was posting at Udalguri.
So you have not yet filed this objection petition.
Today itself we have filed.
Today you have filed.
Yes, lordship.
I have interim PR. Interim PR is open. Next date is on 25th of October. On last occasion, we took adjournment on 3 occasions. So,
Okay, heard Mr. Your good name?
Lordship, I have objection regarding
Learned
interim.
counsel for the, yes.
I have objection because last couple of months the matter is pending before district and session Udalguri. So there might be maximum possibilities of manipulation, lordship. So kindly till the
Where manipulation? Possibility of manipulation is where, in which place?
lordship from petitioner part, lordship. So
Manipulation means, so what kind of manipulation? Manipulation of record or what?
it's just fear, lordship. So kindly till until and unless any order from this honorable court, the proceeding should be continued, lordship.
So we will hear and finally dispose of the matter immediately after reopening. Till that, let there be stay. Heard, Mr. Learned counsel for the applicant, petitioner, and Miss Madam
D.
Colita, learned counsel for the respondent. Miss Colita, learned counsel for the respondent, submits that she has filed objection today, then the same is not placed on record. Accordingly, it is provided that rest shall list the matter on 7 November and take the objection filed by the respondent along with the record. Mr. Neo, learned counsel for the petitioner, submits that there is an interim period of the on the part of the petitioner to stay the proceeding till disposal of this petition. Mr. Neo submits that the marriage between the petitioner and the respondent was solemnized at Vishwanath Saril, and they have lived together at Vishwanath Saril as husband and wife, and no part of cause of action arises at Udalguri district, and as such, it is contended that till disposal of this petition, the proceeding pending before the Court of Learned District Judge Udalguri may be stayed. However, Ms. Polita, Learned Counsel for the respondent, has opposed the petition, opposed the pair on the ground that there is sense of manipulation that at Vishwanath Sariyali, and as such, she has opposed in staying the proceeding pending before the Court of Learned District Judge Udalguri. Where having heard the submission of Learned Counsel for the petitioner and also the counsel for the respondent, and also considering the facts and circumstances on the record, this court is inclined to stay further proceeding of title
Number 2 of 2023.
title suit D number 02 of 2023 pending before the Court of Learned District Judge Udalguri stands stay till returnable date, not till next date.
Publish. Number 30.
May please your lordship. Lordship, notice has been issued to the respondent number 1, 2, and 3 for registered post. But as per office note dated 26/9/2024, neither AD card nor answer notice has been returned back.
Third, Miss
M. Bora, on behalf of Mr. S.P. Chaudhary.
Learned Counsel appearing on behalf of Mr. S.P. Chaudhary, Learned Counsel for the petitioner. Office note dated 26/9/2024 indicates that neither AD card nor unserved notice issued to the respondent number 1 to 3 received by the registry. Leaves the matter immediately after reopening of the vacation, awaiting service report upon respondent number 1 to 3. Further, it is provided that registry shall track the consignment in the website of the postal department and put up one up-to-date office note in respect of service.
31. Please, Lordship. IA 8 and 7 is for release of money deposited by the appellant, the petitioner. So I am the respondent number 2, complainant in the NI case. He has deposited around 20% of the amount.
85,000.
Sorry, 20% of the amount.
Third, Mr. Gogoi, Learned Counsel for the applicant, and Mr.
A.U. Ahmed.
A.U. Ahmed, Learned Counsel for the respondent. This application under this interlocutory application is preferred by the applicant for allowing applicant Nabo Kumar Borua for allowing him to withdraw a sum of rupees 85,000.
Rajan Dev. Petitioner is Rajan Dev. Applicant is Rajan Dev. Applicant. That's number 2.
Okay. Rajan Neuk. Rajan Neuk. For allowing him to withdraw a sum of rupees 85,000, which is deposited by the respondent herein. Respondent number 2 herein, this application. pursuant to order of this court dated 6/3/2024. Having heard the submission of learned advocates of both the parties, this interlocutory application stands disposed of by allowing the applicant to withdraw the amount of rupees 85,000 deposited with the registry of this court.
My lord, subject to an undertaking, my lord,
Not necessary. Not necessary.
State is the number one value. State is of
And
formal.
also heard Mr. B. Sharma, learned additional.
Obliged.
32.
There is a petition, I have petition for disbursement of deposited amount.
Heard, Mr. Your good name, please.
As thus.
As thus. Learned counsel for the applicant.
Yes, please.
And also heard, Mr.
Heir thus, Lordship.
Here does learned counsel for the respondent. Respondent number one.
Purchase.
Respondent
I am
number
respondent number one.
one.
They are
This
the applicant.
interlocutory application is preferred by the applicant for allowing him to withdraw a sum of rupees. What was the quantum?
4,41,155.
For allowing him to withdraw a sum of rupees 4,41,154 rupees.
55 minutes. 55, they have deposited. they have
You come to page number 4 of your application.
Yes, Miller, that's true, Miller.
Then
But actually 50% of the awarded amount is 54.5. Insurance company has.
but
deposited-
what prevents you in writing it correctly in your application?
But I have confirmed from the registry that they deposited the much of amount.
Then you correct this application.
Not all, they are 50%. They are directed to deposit the 50%. But 50% on the basis of that, they have deposited this amount. 50% is 4,41,154.5. So they deposited in around.
Okay, okay, all right. 1,54,000. Pursuant to order of this court, dated 8/2/2023. Mr. Das, learned counsel for the applicant, submits that in fact 50% of the awarded amount amounts to rupees 4,41,155 rupees, and the appellant has deposited the aforesaid amount before the registry of this court. Having heard the submission of learned advocates of both the parties, it is provided that registry shall release the sum of rupees 4,41,155 rupees, which is the 50% amount, which is the 50% of the awarded amount to the applicant, forthwith, in terms of above this IA stands dispose of.
33. Lordship, this IA I have filed for impleting the legal heirs of respondent number 10. This has been listed for the first time. I pray notice may be issued upon the legal heirs.
Yes, you are for?
Yeah, for item number 1 to 9 and 11, my lord. 10 expire.
1 to 9.
Yes.
Any objection?
No, my lord, I have no objection. 1 to 9 and 11. Fine.
Heard, Mr.
G. Bharadwaj.
Learned counsel for the applicant. And Mr.
SR Gogol.
Learned counsel for the respondent number 1 to 9.
1 to 9 and 11.
1 to 9 and 11. This Interlocutory application under Order 1, Rule 10, within bracket 2, reduce section 151 of the Code of Civil Procedure is preferred by the applicant for including the legal heirs of respondent number
10.
Respondent number 10, who allegedly suffered demise on when?
Actually, during the pendency of the first
First
appeal,
April,
During the pendency of the first appeal.
12/8/2021.
12?
12/8/2021.
12/8/2021. Let notice be issued to the respondents, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process. However, no formal notice is required to be issued to the respondent number 1 to 9 and 11, since Mr. So-and-so learned counsel appears and receive notice on their behalf. However, extra requisite copy of the petition be furnished to him during the course of the day. List the matter of 4 weeks.
Volume 34. 34.
None appears for the applicant on call. List the matter after vacation.
Timing 18/19. Lord, it would be 18 and 19. My lord, I have the mark sheets of 9th semester which they have appeared last
No,
time.
not necessary.
Not necessary. Okay.
Mr. Gogoi?
My lord, we'll have to go by what the, my lord, NMC says, because they are the regulatory authority.
Who?
The National Medical Commission.
Acha.
They are the regulatory authority regarding, my lord, MBBS education, my lord. So,
Okay.
my lord, according to them, my lord, prior to 2019, there was no such, my lord, restriction.
Okay. Okay. Then we have to set aside this
Yes,
this order dated
no, there is a
12 to 2024.
Yes, debarment notice, my lord, 12 to 24. But subsequent to this, my lord, they've been allowed to participate. During the pendency of the petition, they again, my lord, participated pursuant to interim orders, and they could not qualify again, my lord. I have got the results.
Yes,
They will
result?
continue till, my lord, till they.
Oh, if there is no bar, then
Yes,
they
of
can
course.
continue.
Yes, they will have to.
My lord, only
So-
one paper remains. Only one paper remains in 9th semester.
Complete it as soon as possible.
Definitely, my lord.
From 2012,
We are disposing of both the petition.
Okay.
42. Bless the lordship. 42. Came here. I mean, nothing fixed price level. S&T. Just this appearance. I think the problem is this. I think the Russell Michelle. I know. Just see what happens, sir.
None appear to the petitioner on call. Resolution is the matter after petition.